Good evening, everyone. My name's Paul Maginn. I'm the director of the Public Policy Institute, and it's great to see you here tonight for our event looking at the constitutional implications of the voice to Parliament. Before I begin with my brief introduction, I'd just like to acknowledge that the University of Western Australia is situated on Noongar land, and that the Noongar people remain the spiritual and cultural custodians of their land and continue to practice their values, languages, beliefs and knowledges. And I wish to pay my respects to leaders past, present and emerging. The Public Policy Institute is a key institute within the University of Western Australia, and I describe our role as one about being facilitating, socialising and promoting policy issues, policy ideas. And I think the panel that we have tonight sits very squarely in that issue. I think it's not an understatement to say that the Voice of Parliament is a once-in-a-generation moment in policy and political history here in Australia. And I'm kind of minded of my own experiences coming from Northern Ireland, of the Good Friday Agreement and the kind of significance of that vote and that decision and the implications and what it meant for people from Northern Ireland and also for the Republic of Ireland as well. So we are at a kind of historic moment and an important moment in our democratic history and our social history and in our cultural history as well. So I'm also very proud to be collaborating with the UWA Law School and the Australian Association of Constitutional Lawyers. And one of our approaches to dealing with socialisation, facilitation and promotion of policy ideas is to be collaborative with different organisations and different groups and so forth. And I really kind of think that this event kind of ticks all the boxes in that front. I'd like to welcome distinguished guests who have come here tonight. I'm just kind of looking around the room and I see the Senior Deputy Vice-Chancellor is here, so thank you very much, Tim, for coming out. Various UWA colleagues are in the room as well, and also you members of the public for coming along tonight here as well to UWA. I'm not going to say too much because Murray Wesson, my colleague Murray Wesson, who's from the law school, is going to be the moderator for this evening, and he's going to be the main show in one sense in terms of leading proceedings. But tonight's going to be, I think, an informative event. We have set it up so that it will be informative and a discussion, and Murray will provide details on how it's going to operate, and he will also introduce our esteemed panel as well. So my thanks to the panel for coming out tonight as well. So without further ado, I'd also like to welcome Barry Winmar, who's a Whadjuk elder and leader. And just to give you a little bit of context who Barry is, our Uncle Barry, apologies Barry. Uncle Barry is a proud Whadjuk Noongar elder with Balladong connections and holds multiple esteemed roles within his community. He serves as the CEO of the Institute of First Nations Wellbeing and Sport, contributes as a councillor for the City of Kwinana, and is the Managing Director of Winmar Enterprises. So Barry, it's a pleasure to welcome you here tonight to UWA, and I look forward to your welcome to country.
Mamanjanagana Kwopanye Kwopanala Bojaye Nala Nunga Bojaye Maman jenagana kwopen ye, kwopen nala boja ye, nala nunga boja ye. I begin by acknowledging my elders past and present, and acknowledge today we gather on my ancestral land. This is the land of the Whadjuk Noongar people. It's an honour and privilege to be here to conduct the Welcome Country ceremony tonight. I'd like to acknowledge other Aboriginal and Torres Strait Islander peoples that are with us here tonight. Did you know Boja Ninik, Nunuk Nining? Then you Kalamai, Whadjuk Mort, Boja Burlu, Double Yergan, Karakumba. Galamort Yeriaka and Jenna Kurling Kurabin, Kalamai Nining Kurling, Borlamort Deutsch Kurajerp. Kalamai Bidip Balap, Mort Kura, Balap Wern, Jenning Yeragenda. Nganjerp Wangan Nunuk, Wajala Mort, Nunga Mort, Nunuk Ma Karij, Deutsch, Jenna Kurling. Ngalak Yening Kurlang Kurlang Galanoich, Nijin Nunga Boja. Nunga Boja, Nunga Mort, Jerp and Ninning, Nijin Galak Kwabadak, Nunga Boja Kurlong. From the beginning of time to the end. This is Noongar country. Noongar people have been graceful keepers of our nation for many, many years. Ngala Jerpan Mama Buja Ngala Bala Mamba Ngala Court Jerpan. Ninyangala Mama Ninning Noongar Buja. We respect the earth, our mother, and understand we belong to her. She does not belong to us. In all her beauty, we find comfort and well-being, and this is now a place where everyone is a keeper of Noongar country. I asked you look, listen, understand and embrace all the elements of Noongar country. It's forever our home. A welcome to country is a sign of mutual respect. We don't take it for granted. I stand here as a member of civilization that has had the longest continuous connection to this land for some 65,000 years. I represent elders and Noongar leaders that have welcomed those from across the shores and this vast brown land, our home Australia, for more than 3,000 generations. And as we stand on this place are the campfires of the Whadjuk Noongar people, where the Budja meets the Bilya, the Derwal Yerrigan behind us, where our campfires burned as we overlooked and watched the sun rise over the Black Hills, the Kalamunda. We understand and appreciate the challenges we've had to get to where we are today. But we also understand that there's challenges yet to come. As First Nations peoples, we ask that you stand with us, shoulder to shoulder, side by side, and walk this journey with us together. As we take on those challenges, no matter what may come, and that we can stand on these shores and watch the sun rise into the horizons, united as one, as all Australians. In our culture, we have a saying for that. It's called Jinning and Bow, looking to new horizons. Jinning and Bow, Jinning and Bow, Karamunda, Jinning and Bow, Noongar Boja, Jinning and Bow, Jinning and Bow, Jinning and Bow. Jinning and Bow, Karamunda, Jinning and Bow, Noongar Boja, Jinning and Bow, Jinning and Bow. And as you listen to the sound and the song, it becomes one with this place, as we are all here gathered, united, as one, as all Australians. Jinning and Bow, Karamunda, Jinning and Bow, Noongar Boja, Jinning and Bow, Jinning and Bow. With the responsibility bestowed upon me by my elders and Noongar leaders, I welcome everybody here today, and I ask that the good spirits watch over each and every one of you while you're at this place and ensuring safe passage back home to your families and to your loved ones after tonight's proceedings. And I say to you, Kaya Wanju Ngan Kot Jerpa Nija Noongar Boja Dajli Wangini Noongar Boja Wanju Wanju. Hello and welcome. My heart is happy as we're gathered here on Noongar country tonight. Welcome.
Thank you, Paul, for that introduction, and thank you, Barry, for that wonderful welcome to country. And I'd also like to acknowledge that the University of Western Australia is situated on Noongar land, that the Noongar people remain the spiritual and cultural custodians of their land and continue to practice their values, languages, beliefs, and knowledge. So those words have become customary at UWA prior to events, but they have particular weight this evening, given that the topic of this panel is the forthcoming referendum on whether to amend the Australian Constitution to recognise Aboriginal and Torres Strait Islander peoples by establishing a voice to the Commonwealth Parliament and Executive. They also have particular weight today, given that the Prime Minister announced this morning that the date of the referendum will be 14th of October of this year. I'd like to say that was planned, but it's entirely coincidental. The Australian Constitution can only be amended under Section 128 of the Constitution, and that requires a referendum at which the proposed law was approved by a majority of the voters, and a majority of the voters in a majority of the states. In other words, not only is a majority of voters required, but a majority of 4 out of the 6 states. Referendums to amend the Constitution are rare events in Australia. There have been 44 proposed amendments to the Constitution since Federation in 1901. The most recent referendum was in 1999, 24 years ago, when the Australian electorate voted against the establishment of a republic and the inclusion of a preamble to the Constitution. Successful referendums are even more rare. Out of 44 proposed changes to the Constitution, there have only been 8 amendments. And the most recent amendments were in 1977, when the electorate approved 3 changes to the Constitution. And those related to the filling of casual Senate vacancies, allowing electors in the territories to vote in referendums, and a mandatory retirement age of 70 for federal judges. The 1977 referendum was 46 years ago. Coincidentally, that's also my age, and that's not just a random observation that I'm making. If I look around this lecture venue, there are many people here younger than me, and what I take that to mean is that many Australians would not have had any experience of constitutional amendment in their lifetimes. And against that background, voting to amend the Constitution can seem rather daunting. And what also makes it daunting, I think, is that much of the debate surrounding the voice has sometimes touched upon quite technical legal and constitutional issues that aren't typically discussed much outside law schools, the legal profession, courtrooms, and so on. And so this event this evening, as Paul mentioned, is a joint initiative of the Public Policy Institute at UWA, the UWA Law School, and the Australian Association of Constitutional Law. And the primary purpose of the panel is to help us better understand some of these constitutional and legal issues that have arisen as a result of the proposal to amend the Constitution to establish a voice. This panel hasn't been organised as a yes-no debate. It's primarily focused, as I said, on those constitutional and legal issues. Obviously, one's views of those issues will inform how one intends to vote, but primarily this is an exercise in civic education to help people better understand those issues. And to assist us in this task, we have a very esteemed panel. Many of our panelists have quite extensive CVs, so I'm going to keep the introductions rather short. To my immediate right is the Honourable Ken Wyatt AM. He was the first Indigenous Australian elected to the House of Representatives and Minister for Indigenous Australians from 2019 to 2022. To Ken's right is Aurora Milroy, who is a colleague of mine in the law school, where she is a lecturer and she is also a Belgu woman. To Aurora's right is Kim Farmer, who is a Noongar woman and principal lawyer at Farmer Legal, where she specialises in criminal law. And we're also joined this evening by the Honourable Robert French, AC, who's Chancellor of this university and was Chief Justice of the High Court of Australia from 2008 to 2017. And the format of the panel will be that I will we'll spend approximately half our time in a discussion amongst the panel, and then we'll open up to the floor for questions. So I do have a slide. And the slide is the Uluru Statement from the Heart that was adopted in 2017. And if you haven't read it, I'd encourage you to do so. It's not a particularly legalistic document at all. As you can see, it's also not a long statement, but it's provided the inspiration for the current proposal to amend the Constitution. It was adopted, as you see, in 2017, but the debate about constitutional recognition actually goes back much further than that, to the 1990s. And I thought we'd start with you, Ken. I was wondering if you could provide the audience with some further background on the debate on constitutional recognition and how we arrived at the Uluru Statement from the Heart as the inspiration for the referendum.
Thank you very much. Let me also thank you, Barry, for welcome to country. That's better. The first referendum was by Prime Minister Howard for recognition, but he had a poet write the preamble, and without consulting broadly with the Indigenous community, put it to the Australian people, and it was lost. Julia Gillard became Prime Minister following Prime Minister Rudd and established a working group with Mark Liebler from a legal firm with Patrick Dodson, as he was then. It was an expert panel of some eminent Indigenous Australians and non-Indigenous Australians to look at the question of recognition in the Constitution, but in that process, the voice. And a report was written, handed to government. Government found the report challenging, and so it established a parliamentary joint select committee to look at the question again. And that was led by Trish Crossing, and I was part of that committee. That committee was about to hand down its report when Parliament was prorogued, and so in the next iteration, Tony Abbott became the Prime Minister, so he re-established another joint select committee to look at the same question, the same issue. And the consultation occurred around the nation, and it came back with recommendations, again for a voice and also for recognition. Now, Prime Minister Abbott didn't like the answer that the report gave. It was tabled in the Parliament, and all parliamentary reports are tabled. So he appointed an independent group with Noel Pearson and a number of other eminent Australians to look at the issue. What they did is they went and consulted much more broadly and came back with the Uluru Statement from the Heart. And given the politics of Australia at that time, there was a change of leadership, and Prime Minister Turnbull received the report of the Uluru Statement from the Heart. I was in that meeting, and when the report was handed over, there was a reaction of saying this is not what we wanted. What we were looking for was a report for which government could make a decision. Mark Liebler and Patrick Dodson both made the comment that this is the will of the people, this is what they're seeking. And on that basis, we then had Barnaby Joyce create the notion there was a third chamber. And that became the catch cry that saw that statement diminished. Prime Minister Morrison established a committee with Julian Leeser and Senator Pat Dodson again to look at the issue, to try and move away from the Uluru Statement of the Heart. That report came back reaffirming the need for a voice and recognition within the Constitution. So you had 4 parliamentary joint select committee reports, all tabled in the Australian Parliament, all known to members of the Australian Parliament. The Uluru Statement was never tabled but was referred to in the Australian Parliament. But that had the impetus and support of Indigenous leaders to become the basis for the campaign to have a voice. And the voice was asked for on the basis that there have been numerous national Aboriginal and Torres Strait Islander committees that have been established and abolished by governments. I was on the National Aboriginal Education Committee for some 7 years. John Dawkins called us in and thanked us for our work and said, "You're all dismissed." And so that was the end of the National Aboriginal Education Committee. And there were numerous other committees. And so that's why the reference to an enshrined voice is to ensure that governments do not take away an avenue for advocacy for Indigenous Australians from the community level, regional and to national. It's not a Canberra voice, it's not the Albanese voice. It is a voice that has been talked about by Indigenous Australians through numerous reports. It has been consistent and it hasn't changed. And what it fundamentally says in all of those reports, please listen to us. Listen to our viewpoint on policies, programs and services. This is what we want, but we want it guaranteed. So that's the context. I had courage of it, and what's interesting is listening to my former leader speak against the voice. But I have 2 charter letters, and as a minister you receive a charter letter, and that charter letter spells out the jobs that he wants you to do. Voice, truth-telling, and one other. No, I've got to think of the third one, but I'll think about that later. No, treaties wasn't part of it. But fundamentally, the voice was in my charter letter. So my first speech was about the voice, based on the authority given to me by the Prime Minister. And that was at the beginning of a coalition government. And ultimately, that's the reason I took my stance and resigned at the time I did. But that's the context for the voice. It is not a threat to any Australian. And if you read all of those reports, it's about our people having a say.
Aurora, in the Uluru Statement, there are a few different elements. There is a reference to a voice, but there's also a reference to a Makarrata Commission that will supervise a process of agreement making between governments and First Nations and truth-telling about our history. I was wondering if you could talk us through the Uluru Statement in a bit more detail and how these different elements interact with one another.
Okay, thank you, Murray. So I guess everyone's probably heard this catch cry of the Uluru Statement, the Voice, Treaty, Truth before. So those are kind of the 3 main elements, though there are other aspects to the Uluru Statement as well. It talks about Indigenous sovereignty, it talks about also Indigenous disadvantage and the gap that we have to fill. But the key 3 elements are voice, and then via the Makarrata Commission, agreement making or treaties, and then truth-telling. When they drafted, or I guess some of the proponents of the Uluru Statement who've been speaking quite prominently about it have spoken about the order of the reforms. So these are kind of seen as 3 structural reforms in the statement. And those that order is really about saying, let's get this first one through the door, foot in the door with the voice, that sets up our ability to oversee things and have a say. Then we move on to agreement making, which can be quite a long, slow process. If we think about the treaty process that's already happening in Victoria, that's a number of years, and we're only sort of just starting to see things forming up a bit. And then finally moving to truth-telling. And I think there's a lot of different views about the order as well. So some people would say truth-telling comes first in these processes because you want to sort of get everything out on the table before you start the structural reform. But I think the intention really was saying, actually, we've done a lot of truth-telling over the years. We've spoken to the Royal Commission into Aboriginal deaths in custody. We've spoken to the Bringing Them Home report, into the Stolen Generations. We've given our testimony as Aboriginal people. We've told our truth. And actually, it can often be used by governments as a way to sort of move away from some of those larger structural changes. So let's talk about the truth, let's keep talking about the past, and then never actually do some of the bigger pieces of the work because we get distracted by that. So the aim is really to say, let's get a foot in the door with the voice, move on to treaties, and then do truth-telling. And the other thing to remember, I guess, which ties in with this idea of testimony, is that truth-telling isn't about Indigenous people telling our truths again and again and again. It's about non-Indigenous people speaking truth as well and acknowledging this history and how we can move forward together. I think it sort of, to me, ties in this sort of where we get that assumption, reminds me a bit of something that actually Jacinta Price says in the No pamphlet, which is we don't need a voice, we need ears. And I think there's some sort of truth in that, which Indigenous people have always had a voice, and we've always brought our voice to the Parliament. We've always brought our voice to the government as well. We've done that for a very long time. We've had some really prominent activists, but it's about listening that needs to happen. And so I think what the voice really is about a structure or a means for that listening to occur. And it's the same with truth-telling. It's about how non-Indigenous people respond to that truth and how we accept that and move forward together into a different space. The other kind of obviously contention around timing is whether people say that the treaty should be first. And I think that, there are treaty processes already underway and these things can all happen concurrently. So I don't think there's any reason why you couldn't do treaty and voice at the same time as well.
While we're on the Uluru Statement, do any of the other panellists want to add anything to that discussion? Aurora, do you want to just elaborate a bit? Because I'm aware that we have lawyers and non-lawyers here on the distinction between voice and treaty.
Sure. Well, I guess from a legal perspective, the aim of the voice is kind of something that has to be in the Constitution. So it's saying we're going to establish this body that exists to speak to both the Parliament and to speak to the executive government or the sort of public service, the ministers who do the action, make the decisions. And that body, the nature of its powers and functions and what it does is determined by the Parliament. We know that from the proposal. So that's really about having a voice on the matters that affect Indigenous people that are going through the Parliament and going through the executive. All those decisions around funding and programs, the sort of next stage of reforms and things we want to do. Treaty is really a kind of different process. It's a sort of nation-to-nation process. So if we think about Indigenous communities or nations or groups or languages, whatever you want to call it, however you want to view it, the agreement-making process is between this government that we have and Indigenous peoples about how we want to be in a relationship with one another going forward, setting the terms of that relationship. And that can sort of lead to broader things if we see other contexts, like in New Zealand. Then we have something to hold us all to account in the way we've agreed to work together as nations, as independent sovereign peoples as well.
I just add to that. I'm not sure there is a hard and fast distinction between voice and treaty in this sense. The proposed amendment has an act of recognition. It says in recognition of, as Australia's First Peoples, and the act of recognition is the establishment of the voice. Now you can see that as the elements of something which you could call a treaty, part of the infrastructure.
Well, on the subject of the amendment, let's take a closer look at it, what's actually proposed. And this is the proposed amendment to the Constitution. It won't be on the ballot paper itself. There did be a question about whether you wish to endorse the amendment, but this is the new chapter that will be added to the Constitution if the referendum is successful. I will ask Robert in a minute to talk through the different elements of how these sections will work. Before we get to that, though, at least anecdotally, and even listening on the radio this evening on the way here, probably the concern that I've heard voiced most is that there's a sort of absence of detail about what is being voted for. So you can see this proposed amendment, which refers to the establishment of an Aboriginal and Torres Strait Islander voice, but there's a concern this doesn't tell us enough about the nature of the voice. Kim, would you like to comment on that? And I think other members of the panel will probably have thoughts about that too.
Sure. So is there enough detail already being provided? And the short answer is yes. It has to be what has been provided. There's a booklet in everyone's letterbox this week or last week, and there's a lot of detail, there's a lot of coverage. But it's not so much that there hasn't been enough detail, it's just how can you message that to 17 million people that are so diverse. As you said, there's most people, a huge percentage will never have ever even thought about a referendum, let alone this year having to participate in one. There's people that are never really have had much contact with Aboriginal people, so have virtually no understanding of the background of what has happened. There's people that come from very culturally and linguistically diverse backgrounds, and people from all walks of life, and they're all having to get the same messages. And there's the people that you heard on the talkback show, the people in the room here who are informed but hungry for more information, for more clarification. And then there's the huge body of people that are somewhat overwhelmed at this stage and a little bit frozen. And then, unfortunately, then you get messages like, if you don't know, don't worry about it, just vote no. And, that's a concern, and I would imagine would probably offend pretty much everyone in this room as informed, intelligent people. So how do you make that happen? And then if we take our experience from past referendums where when it gets complex, it's less likely to succeed, to keep the message simple, to stay to the question. And I think it's really important and somewhat a relief that the date has been set and we've now got 6 weeks to go. And already I have this feeling of hearing that the answer is the simplification and the clarification. Mr Albanese, in his visit to Perth yesterday, was simply saying it's this simple. It's about recognition. And it's about hearing from Aboriginal people who are affected by this. So he gave examples. If you want to know about Western Australia, you'll go and ask people that live and work in Western Australia. And other simple questions. I've seen an opinion article this morning that expanded on it, saying this is how governments work. If you're building roads, you'll go to people that are road users and you consult with them. If you're a school, then you want to build a playground, you go to parents of school children and you consult with them. So you hear from the people, and that's where the most impact. It's not more complicated than that. So I think this is a really important time, and I think the next 6 weeks we will get the clarification and hopefully the long lead that very negative, but a small group, I think, negative voices have really taken over a lot of this debate. I think that's going to ease away and we're going to get hopefully some real clarification and I think we'll be moving forward on that. Did you want to say something?
Does anyone want to add to this question of detail? So, for example, on the radio this evening, I heard someone who was being interviewed at Hillary's in Perth saying, well, I want to know the composition of the voice, who will sit on it, how it will be elected. That's the kind of detail that I feel I require as a voter. Is that the sort of question that should be asked, or is that not the right question to be asking at this stage?
Actually, it's a question we should have asked of all legislation. In this country, we do not interrogate legislation that is brought before parliaments as citizens. And yet, we accept legislation that has a profound impact. The anti-terrorism laws. Everybody thinks that applies only to terrorists. Let me tell you, when you read that legislation, that applies to any Australian who is considered suspect. So we're not exempt. The taxes, superannuation, all of those, when they're brought forward, are done with industry. Let me share with you that any legislation that is brought into the party room, the ministers must demonstrate who they have consulted with within the industry. And it'll have a list of all the organisations, both social, certainly industrial and mining companies, but other key organisations who have a pertinent role in that legislation. I did an analysis of Coalition Party Room papers on legislation, and it was only on Indigenous-specific ledge that we asked for any Indigenous input. On health changes, which have a profound impact on every Australian. There was no consultation with NACCHO nor with Indigenous organisations on education. In the key areas that impact, no evidence. Yet I hear the argument saying that by giving Aboriginal people a opportunity to have a say about legislation, that they will have a power of veto or they will have an undue influence. And yet the mining sector, and let me share with you the campaign you're seeing at the moment with the Pharmacy Guild. The Pharmacy Guild, the pharmacists aren't happy. So they have their national body, the Pharmacy Guild, advocating for the government to repeal the legislation so they can go back to monthly dispensing of medications instead of 2 monthly. That's a concerted campaign by a peak body. We accept that as a nation. But on this one, we ask for detail. We ask about membership. But we don't ask that of bodies we establish, where governments appoint people to bodies associated with legislation. And that is a consistent pattern and behaviour across legislation at state, territory and Commonwealth levels.
Robert, I think you wanted to add something?
Yes, if I could just... I think it's on, yep. This is a constitutional amendment, and no amount of stated detail by the Prime Minister or anyone else can be guaranteed to be brought into effect, because the detail depends upon Parliament, and that in a sense is a protection. So we have this constitutional amendment, which, if I can just take us quickly through the elements, you look up at the words, you start off by saying it's an act of recognition, because it begins with the words "in recognition of Aboriginal and Torres Strait Islanders as the First Peoples of Australia." Very important that it is an act of recognition, because that tells you, and the capacity in which that recognition is extended. It's not a race-based recognition. It's based on the historical reality, the status of Australia's First Peoples as the first history of this country before the 1901 Constitution. Now, you hear, of course, one of the arguments put against it is it's race-based, okay? Yet there's a quotation which I've got somewhere from John Howard, who talked about recognition as based on the status of the First Peoples. Now, if you're prepared to accept that recognition in the Constitution is not race-based, how can you argue that an act of recognition which constitutes an advisory body as a voice is race-based? So it's a very first important step to look at that. And then when we see there shall be, what does this act of recognition consist of? This gives the substance to recognition. It's not empty, it's not symbolic. There shall be a body. What's a body? Well, we know what a body is. A body is a group of people. Now, it doesn't tell us more than that, to be called the voice, etc. Secondly, this body can do certain things, and it's a broad statement of its functions. It may make representations to the Parliament of the Commonwealth or to the Executive Government of the Commonwealth on matters relating to, etc. Okay, so it may make representations. That's just official statements. So that can take the form of advice, it can take the form of comment, critical or otherwise, or it can take the form of advocacy. But none of that is a binding, has a binding effect. You can't, for example, qualify the Parliament's power to make laws by representations or by any manner and form of requirement to have regard to those representations. That's left to the Parliament to determine. And similarly, it may make representations to the Executive Government of the Commonwealth, where, of course, we know a lot of the realities of our laws happens. The policies, the practices, the person behind the counter with the manual, the so-called soft law, that for very many people is the law, regardless of the statute that sits right behind it. So the importance of representation being able to be made to the Executive Government of the Commonwealth is very significant. That term, by the way, the executive government of the Commonwealth, is not defined in the Constitution. It's used, but rather unhelpfully not defined. But at least it means the Governor-General, it means ministers of the Crown, and it can probably pick up senior public statutory office holders. The third element, which you'll see there, the Parliament may make laws, including laws as to the powers, composition, functions, etc. of the body, tells you that it's in the hands of the Parliament to set this voice up, to say how it will be constituted, how its members will be elected, what their powers will be. And it can also, and this was made clear in the second reading speech by the Attorney-General Mark Dreyfus, it can also make provision for the legal effect of representations made by the voice on executive government. So this talk about, as it were, choking up executive government with legal challenges is, in a sense, put to bed by that power of the Parliament to control it. Now, the Prime Minister has, of course, announced some what he calls design principles, very broad design principles, and they reflect what appears in the Karma-Langton model, which is just one possible model for the voice, with elections from representatives from remote and rural areas and so forth, and 24 people with decision and with advisory powers. The Parliament can decide how representations will be made to the executive. It can decide, for example, that they can only be made through the minister, so you're not choking up the Reserve Bank and all sorts of other people with the sort of scare scenarios that have been put up. But if the Prime Minister were to stand out in public tomorrow and hold up a detailed bill, this is how the voice is going to work, all he can do is promise that he'll bring it into Parliament. He cannot guarantee that the Parliament will enact the voice in those terms. The detail cannot be constitutionalised. And that's true if you look at all the provisions of our Constitution, they are broad brush provisions, and the detail is filled in by the legislature. So the problem about not knowing enough detail is really, in a sense, it's a false problem. The protection is that, in the end, the detail will be determined by our elected representatives.
Can I just add to that? That set of words in that last line, that last point, was developed by the Indigenous Reference Group that the Prime Minister and Minister Burney established. I was part of that group. And in our discussions, we recognised the sovereignty of Parliament. And in putting those words together and having the endorsement of the Solicitor General and the Attorney General, it was an agreed position of all of us. So it's not just a government position, it was worked through by Indigenous leadership.
Robert, if I could just draw you a bit more on this question of representations to the executive, because there have been some arguments made that it might be possible to draw some sort of implication from these sections that the executive either has to listen to the voice before exercising discretion and making a decision, or has to follow a representation of the voice. Do you think that's a valid concern? Or I assume not from what you've said, but would you like to expand on that a bit?
Yeah. The first possibility that you mentioned, the second possibility you mentioned, that the executive government might be bound by a constitutional implication to act in accordance with a representation or advice from the voice, that's just a total non-starter. There is no way that that would be implied from the Constitution. I don't think anybody's really suggested that. Where there has been debate is around the proposition that there might be a constitutional implication, in other words, something to be inferred from the provisions of this Act, but not in its, of this amendment, but not in its text, that people exercising the executive power of the Commonwealth, either under a statute or under the Constitution itself, would be bound to have regard to a representation made relevant to the decision that they were required to make. Now, there might be some traction in that, but that's covered in a sense by the third provision, which gives the Parliament the power to make laws about functions, powers, etc., including, although it's not spelled out there, the legal effect of the of representations. Now, I think even without that, it would be a very long bow to find an implication in the Constitution making consideration of a representation, what they call a mandatory relevant consideration, which would condition executive power. In other words, you couldn't exercise executive power validly unless you had taken into account the representation made by the voice relevant to that. And the reason for that is this. The High Court's recently said something about constitutional implications. And the test for a constitutional implication in this sort of situation is it's got to be necessary. In other words, the implication has to be some rule or principle which is necessary to enable this to work, okay? That's the kind of test. Now, the problem is that the power to make representations under subsection 2 covers not just the executive, it covers the parliament. Now, there is no way that the parliamentary lawmaking power is being confined by a requirement to have regard to a representation made. No doubt the parliament will make rules under which representations will be notified to the parliament when a bill, for example, is introduced. But these are the sort of rules that are not enforceable in the courts. So that application of the power to make representations to the parliament doesn't give rise to a justiciable, legally enforceable obligation on the parliament. Now, then when you get to the executive government, there's a whole range of functions of the executive government upon which representations might be made. And there are some of those areas, a large part of it is what we call high policy. In other words, it's not specific decisions and not the specific exercise of a statutory power. It's the making of general policy, which is, again, non-justiciable. You can't go and argue about generalised policy making in the courts. Now, that leaves a small set of executive decision-making where they're actually exercising a legal power under a statute, or maybe in some cases a legal power derived from the Constitution itself. Now, the question is, could you find an implication that they have to take into account representations in exercising that narrow band of executive functions? I think it is highly unlikely, having regard to the broad application of subsection 2. I mean, it's possible that it could be argued, and as I've often said to people, if your barrister tells you that you cannot lose a case or you will win a case, you'll say, I think I need to go to another barrister. Because you're really predicting the views of other people, the judges, for example, in the High Court. So I cannot say that there is no chance, certainly no chance it would not be argued, and I cannot say there is no chance that the implication would be found, but personally I think it's a very low risk.
Kim, different question. When we spoke last week, you said that one of the issues that's been raised most with you in these sorts of forums is that there's a diversity of views amongst Indigenous people themselves, and not all Indigenous people support the voice. Would you like to discuss that?
So it's in forums like this, but it's also in conversations with people that are informed, and comes as a bit of a shock that one of the issues is the surprise that non-Aboriginal people have that not all Aboriginal people want this. And simply explain a couple of things. One, this is a very diverse country. When the first fleet arrived and up until the Constitution was written, there was 250 languages estimated, probably many more. How would you really know? Hundreds of dialects across all of Australia, living very different lifestyles. You cannot compare the Torres Strait and Islands to the desert, the coastal living, to everywhere. So why must all Aboriginal people have the same view? And then the other really key and fundamental thing is that since the first fleet, and really in the last few generations, since the Constitution was written, the most intensive government actions have impacted on every aspect of Aboriginal people's lives. And today, Aboriginal people directly or have inherited those traumas, and it was governments that did this, or representatives of governments, wearing uniforms often, coming in white cars, taking children away. So would you all of a sudden think, this is the first time I give my full trust that this is what's going to happen, what the government's saying is going to happen is going to happen. And so that explains why there is a diverse and that not all Aboriginal people, but nearly 100% would agree what the system is and what has happened to date isn't working, and that there needs to be changed. And you look at how the Uluru Statement was formed. It was formed by consensus of approximately 1,200 signatories that represented peoples and lands from all around Australia. That was consensus. And so I think even the Reconciliation Australia or WA have done some polls, and the two that have occurred this year is 80 and 83% Aboriginal people support the referendum in the way that it has been proposed.
Slightly different question, Aurora. One of the other sort of sceptical arguments I've heard a great deal is that the voice itself implies a form of inequality. And I'll put the argument like this. We already have a system of representative government in Australia. Indigenous people can vote in that system. There are Indigenous Australians in the Commonwealth Parliament. And that establishing a voice creates a kind of inequality in that Indigenous Australians are, so the argument goes, already treated as equals by a system of representative government. I think coupled to that is an argument that there's a division on race, which I think Robert's addressed already, so I won't ask about that, but specifically about the inequality point.
Yeah, so I think this particularly comes through in the No pamphlet again, which talks quite a bit about the idea that this is a divisive measure, and particularly that it will lead to sort of special protections or special rights for Indigenous people and undermine sort of this notion of equality. I guess broadly speaking, the idea of equality is that everyone has the same rights and is treated equally. But I think both the Yes and the No pamphlet already acknowledge that that's not the case, because both talk about the large gap in outcomes between Indigenous and non-Indigenous people. They talk about the disadvantage. So we know for a fact that we're not starting all at the same level, and therefore you can't really apply this lens of equality for all. We also know specifically that the Constitution, when it was drafted, did not have equal rights for all people. It excluded, Indigenous people were mentioned by exclusion, so not to be counted. One of the very first things that the new government did was institute the White Australia policy. It was written by old white men who are now long dead. So the idea that it sort of incorporates equal rights in a system is a bit of a falsehood, really. And then you think about where we are now and what would actually be needed to achieve equality. It's quite different. It's sort of more of an equity mindset you'd have to take, which says, where are people now and what do we have to do to bring everyone up to the same point? But I also think there's some difficulty in thinking about equality as this sort of virtue that we should always be seeking as well. Auntie Mary Graham is an Indigenous academic, and she talks about how Western governance models are based on this idea of equality. But in an Indigenous governance model, we actually strive for balance. So thinking about not everyone having to do all the same things, but thinking about how we are all unique and different and have our place in the system and how that system works in an operation of balance. So to me, this voice proposal isn't really about equality. It's maybe about sort of addressing some of that disadvantage and inequity that Indigenous people have experienced through the history of colonisation. But it's also potentially a way to bring in the unique and defining voice of Indigenous people to help restore sort of balance into this system as well.
Okay, I have one more question for the panel before we move to questions from the audience. And I'll put this question to Ken. Another concern that's been raised is that the argument is that there are already bodies that represent Indigenous views to the Executive and Parliament. So one of those that's been mentioned is the National Indigenous Australians Agency. And the concern is that the Voice would create an additional and unnecessary layer of bureaucracy that wouldn't necessarily lead to improved outcomes for Indigenous Australians. So I'm interested in your perspective on that as a former minister in government.
The National Australian Indigenous Agency used to be a section within Prime Minister and Cabinet. When I became minister, it was taken out so it could focus on the priorities that we had to address as a government. But their work was to do cross-portfolio work. In closing the gap, their task was to coordinate government activity across every area that had an impact, both directly and, in some instances, indirectly on Indigenous Australians. But they were also to be an advocate at the local level to work with communities and groups to help them in the establishment of programs where decisions had already been made to put into place whatever service it was. Now, the agency is not all that large, but the combined public service is. And the intent was for them to harness the public service across every layer of government to become a conduit to making a difference at the community and regional level. But that hasn't happened. And the other element to this was to coordinate activity in closing the gap. Now, the closing the gap was done in partnership with 51 peak organisations and every Australian Minister for Aboriginal Affairs and senior public servants. When that was finalised after 2 years, Commonwealth Cabinet endorsed it, National Cabinet, and then every state and territory cabinet. And the idea was for the agency to continue working across those portfolios to ensure that we made progress. It is not the Voice, but it will assist when the Voice is established, working closely with regional structures and at the same time still linking with communities. The number of Aboriginal people employed in that agency is not all that large. It is predominantly non-Indigenous Australians from the remnants of previous iterations of Aboriginal affairs. There are people whose belief is a do-good approach, and that's not a criticism of the agency, it's a criticism of some individuals, because we have to make some tough decisions and tough love calls, and that's what the agency is required to do. But it is not the panacea for the Voice, and it was not intended to create a new bureaucracy. When I was minister, that was never my intent. My intent was to use resources and fund communities with existing capability and capacity and build that capacity. Now, Aboriginal organisations that exist serve a purpose in a particular field. So, Aboriginal community controlled health services, Aboriginal education consultative groups that exist. They're not consistent across the nation, and that's part of the challenge. The most effective organisations are the Uluru people, where they still keep the clan leaders, and that community works within cultural structures. The Torres Strait Island region, and then as influence of change is impacted, then you have different iterations. But not all of them have a national position where they can reach down to a community and then take those positions into state and territory governments nor into national governments. So that's why the Voice is important in having consistency. And I'm reminded of a comment by Ned Hargraves after the event at Yundamu, the shooting of the young man. I met with all the elders and he said to me, "How does my voice get heard by you in Canberra? If you're my minister, then how does my voice get heard?" And I said to him, land councils and the agency, and he said, no, they don't translate it. So that's why I gave a heavy emphasis to having a voice at the local level so that we could really hear from people.
Okay, let's move to the audience. And if you'd like to ask a question, we have some roving mics. And please just raise your hand. And I can see a question already. What I'm also going to ask is, when you ask your question, if you could please stand up. That's just for the benefit of the cameras that we have. You may want to say who you are. And you may also want to say whether your question is addressed to a particular member of the panel or the panel as a whole.
My name is irrelevant. I'm a privileged white Australian male. 50 years ago, Finland established Sami Parliament. 34 years ago, Sweden established a Sami Parliament. In 1987, the Sami were recognised in the Norwegian constitution as the indigenous population. Is it beyond wit that, given we have 50-odd years of experience elsewhere with these organisations established and working, is it beyond wit for Australians to actually figure out what to do? And the second part of that question, are we any less than Norwegians, Swedes and Finns in our capabilities?
Okay, does anyone want to take that question?
Let me acknowledge that it's a good question because I'd heard about the Sami Parliament when I was at the World Indigenous Peoples Education Conference in New Zealand. And I was always fascinated that they had the position within their countries and they did influence governments. What I didn't know until I went to Geneva to the World Indigenous Peoples Conference, and what was strange is I was the only minister from a government there, which means that a lot of governments didn't send ministers. But in talking with them, they said they were a parliament by definition, but they operated through the Minister for Justice. But it still gave them a pathway into the executive government. And in many senses, the voice would emulate that. So it has no authority, but it certainly has influence. And I've just forgotten the second part of your question now.
Are we less than the Scandinavians, I think was the second part of the question.
In a sense, we shouldn't be less as a nation. We've got 200 odd years of history that I believe truth-telling should take us back and allow us to learn from the mistakes of the past, not to lay guilt, but to say we made mistakes there, how can we do it better? And I want to use the example of the Mile Creek massacre. Aboriginal and non-Aboriginal people came together. They talked about the massacre, who were the families involved on both sides. They have now built a monument that has named all of the families, those who were killed on that day, plus the other families who were involved. But they talked about how they would never make it happen again. And they are working closely together to have a better future in those communities. And that's what we should be doing as a nation, standing up and taking those processes. I think Aurora touched on it earlier. It is about a shared journey together, because my aspiration is that we have a better outcome for our grandchildren. So they sit there as Australians, but proud of their different ethnicities, but working towards one common direction.
Are there other questions? I should just say too that some constitutions are more rigid than others, meaning they're more difficult to change. And I'm not familiar with the Scandinavian constitutional arrangements, but it may be that those constitutions are more flexible, meaning that these sorts of changes are easier to make than they are in Australia, where we have a referendum requirement. Okay, so I think your hand went up first. So there's a mic.
I'd like to address a question to Mr. Wyatt.
Are you able to, would you like to stand up?
You express quite a lot of optimism in this voice, and I read there that the representations may be made to Parliament, but there's nothing there that says they're going to be listened to. So is this possibly going to then create some uncertainty and disappointment, or is the assumption that you will be listened to and action will be taken? Did you use the word guaranteed earlier?
I used... Actually, I'm not sure whether I used the word guaranteed, but what I was striving for and what the Voice is striving for, and I know my colleagues that have been working on the Indigenous working reference group to the government are wanting governments to listen. And when you couch words for a constitution, and there were many iterations of this, by the way, that we thrashed out, we can't guarantee that someone will listen to another. What we create is an expectation that courtesy will apply and that you will take the time to listen. When I was minister, I had a women's group come and see me and say that they had met with 3 of my colleagues. And I said, so did you meet with the actual minister? And they said, no, we were told at the last minute that the minister couldn't meet with us, so we met with their senior advisors. They were disappointed because they were expecting to talk to the minister. And I said to them, at least you've made your view known to their senior advisor. I will follow up. But once this goes through, then there will be a push by our people to make sure that listening occurs by invitation. We should be doing it with all federal members now, and I know there are federal members who have never sat their backsides down in the red dirt and talk to a whole community. They talk to an organisation and take the organisation's view as the reflection of every voice. Election times, we're great at listening. We come and knock on your door. We phone call you to seek your views, or we hold a town hall meeting. Or if we see you somewhere, we grab your hand and shake it and say, hi, I'm the local candidate, or I'm the member. So we do engage during that period, but I wish we would do it consistently with Aboriginal people as well.
Can I just jump in on that one? Because I think your question really gets to the issue of trust, right? And I think this is also one of the key issues that comes across that Kim's already talked about in why a lot of Indigenous people might be on the fence about this proposal. I remember I went to the 4 land councils in the NT sort of launching their treaty process, and the T-shirts had 30 years of broken promises on the back of it, so all the public servants couldn't take them home. But essentially, the issue is it's really hard to trust this government. It's like getting into a new relationship, right? Like, is this person going to be any different to the last person that broke the promises and lied to us and didn't deliver anything? But all you can really do is try to trust and give it a go. And it's sort of trust is also 2 ways. We need to ensure that governments start to trust Indigenous people and know that we know what we're talking about when it comes to Indigenous issues. So, yeah, I feel the fear. I understand it too. I've seen, I'm the youngest one on the panel, but I've definitely seen it in my lifetime, how things haven't been listened to or actioned as well. But I guess this is just saying what's the alternative is not doing anything and then we get nothing. So it's about saying let's try something to see if this time it does actually work. And we're still allowed to go off and be independent women and build up our Indigenous nationhood and all of that stuff, but we can try this as well.
Robert?
It'll be very important that if the Voice is established, that the Parliament establish a mechanism for receiving representations, both as to existing laws and as to proposed laws. And the real imperative there won't be a legal imperative, it'll be the political imperative, because there'll be a significant, what I call democratic mandate if the referendum gets up. The Parliament has to be seen to respond. Now, there's a variety of ways that it can do that. One way is to establish a permanent point of communication, for example, a joint standing committee which can interface with the Voice. And there can be another mechanism requiring, we have laws like this, for example, in relation to human rights scrutiny and so forth, requiring ministers presenting bills to the Parliament to have a statement attached to the bill indicating whether they have received any representations, whether they've been consulted and to what extent that is reflected in the bill, and that itself might be the subject of scrutiny by the committee. So there's a variety of mechanisms which can be set up and which are already analogous, for which there are already plenty of precedents. I think that the real force of the voice will be the democratic mandate rather than the legal mandate. And of course, the persistence of that will depend upon the credibility and reputation that the voice establishes down the line in terms of how it exercises its powers.
Okay, before we move on, because I know there was another hand, Kim, do you want to add anything to that? Okay, I think there was a hand there.
Hi, I'm Katie Atwell. I'm an Associate Professor in Public Policy here at UWA. Thank you for a great panel so far, really interesting. So my question kind of comes in two parts, and they both lead to the same place, but I need to articulate them both separately. Mr. Wyatt, you talked about how people don't ask. It's about the composition, by the way. It's about the composition of the voice, so that early part of the conversation. So, Mr. Wyatt, you said that people are not worried about the detail and the sort of composition of the other groups that might be lobbying or making representations even formally to government. And you sort of said, well, why are people worried about this one when they're not worried about those ones? And I reflected that they're worried about this one because they're being asked about this one. They don't know about those other ones, and if they did know, they would probably wish that they had input and a say about the composition of those too. So the fact that they, that they let those processes go past is only because they don't know about them. And my concern, therefore, is that they're being asked about this one, and so this will get the whole piece of, well, we don't like any of them, we don't trust any of them, we don't believe, any of them are making decisions in our interests. I'm talking about the potential no vote here. And then related to that is the other point that was made by the Chancellor, where we learned, okay, actually you can't constitutionalise the composition of the voice. It has to be done by Parliament. I am almost as old as the chair, and I remember very well living through the Constitutional Convention and referendum about becoming a republic. Australians said no ultimately to a republic because they didn't want Parliament to decide on who the leader of the country would be. They felt that that should be in the hands of the public. So I'm seeing various things here that are pointing us back to people needing to trust their parliamentarians, people needing to trust decision makers and to trust processes that go on and consultations within government. But we're living in a time where that trust is incredibly low. So I'd really like to hear how the panel suggests we might deal with that if we would like to see the voice established.
Okay, I think that question was put to you, Ken, primarily, but I'm sure that the other panellists will have thoughts on it.
Actually, ex-parliamentarian, I'm enjoying retirement. The issue this is scrutinised is because of some very strong individuals who just opposed the voice. I used to look at dismay sometimes at our lack of engagement as Australians with our political structures, because we should be scrutinising some of the bills that go through. I love reading the High Court decisions. And there's a reason for that, because the Timber Creek decision is a profound handing down of a Supreme Court decision that has got implications that people have no idea about. The recent one for the Yolngu people has got profound implications. The Attorney General is going to have to appeal it. The Northern Territory Cattlemen's Association versus Ludwig has got a key issue for ministers about misfeasance. Ministers haven't read what the implications are for them. So we as a society tend to focus on those louder things that are brought to our attention. Now, I would trust our people at the regional level to select the candidate that they want as part of the national voice, because that's where the decision is for the Canberra voice. Not with government, but with them. So that will have a different emphasis in the way in which that's done. And I remain optimistic because ATSEC regional councils worked. The commission was the problem, the commissioners. And that's where government used their powers to abolish the whole of ATSEC. And our people, through election processes, elected people they believed could do the job. But in some instances, large families elected a family member. That happens even now in our own political systems. So the choosing of people and the broader community asking for the detail is about a lack of understanding of the complexities of the issues within Aboriginal affairs, Aboriginal communities across this nation, and the geographic diversity that our people face. Nothing has worked for us. And if you ever, and I'm glad you touched on the NT, I wished I'd grabbed one of those T-shirts. But the NT people do not trust government because of the intervention. Nobody was charged on sexual abuse charges based on the Little Children Are Sacred report. And yet the most draconian measures were taken. Decision-making was taken out of communities. Elders were not allowed to make decisions that went to local government. And that has created absolute consequential flow-on issues. Membership is going to be questioned. I hear it on 6PR every day. I wished I had simple answers, but it's up to our people. It's also up to Australians to have some faith that we are capable of making some judgments and putting people into place that can do the jobs. And the detail will come with our politicians. And I said this on the 7:30 report tonight. Even the coalition will have a say in the ledge. So they're about to debate what the legislation is. So the furphies that you're hearing are clouding the clarity. And that's what I find sad with this campaign. I also didn't vote for the didn't vote for the Republic on the basis of the politicians selecting that person, because I think Australians wanted to elect the president of this nation. I think there was a view, though, that if you made it politicians, it would be lost. And look, used car salesmen are more popular than pollies.
So there's a lot in that question. Does anyone else want to respond to it? Any other questions from the floor? Okay, a lot of hands went up at once, but with the wearing the glasses, I think was the first hand.
Hi, I'm Beck. I'm an occupational therapy student at Curtin. Don't tell anyone. My question is, the panel have commented on previous Indigenous bodies and noted that they've been abolished by subsequent governments, and some people may criticise that they haven't made the changes that needed to happen. So why would a constitutionally enshrined voice, which is also comprised and given powers by the government, be any different? How do we know we won't have a different voice every 4 years, which may be allocated no power or consequence on Indigenous matters, especially when we have an opposition that doesn't presently support the voice?
Would anyone like to take that question?
Well, I think if and when, and this is why there's some significance in having the voice in the Constitution rather than simply a legislated voice. The legislated voice is far more vulnerable to the ebb and flow of political tides, whereas if it's in the Constitution, then it has a status and prestige which has to be recognised. And I think it becomes politically more difficult to undermine. Now, it's not impossible. There used to be there's a thing in the Constitution called the Interstate Commission, which had certain functions, and ultimately that kind of withered on the vine, and the way they got rid of it effectively was to defund it. Now, there may be some questions about whether once you've established a voice, what are the limitations on the sort of changes you can make? Can you make changes which are incompatible, for example, with its constitutionally mandated function? But what I think will count more than anything else in the end is the reputation that the voice establishes for itself in the way that it engages with government, its political realism and its ability to prioritise what really matters. And if I can just add one other comment, the devil will be in the detail. And we can say that there's not a monster lurking out there behind the fog, which is a detailed voice waiting to happen. That's going to be a process, and it's going to take quite a bit of time. And for myself, I think one of the greatest challenges, early challenges for the voice and for the Parliament in determining how it's going to work is how does it engage with the different levels of government around Australia? Because when you think about it, the rubber hits the road on Indigenous affairs very much in the area of state and territory government responsibilities. Now, the Commonwealth has very important funding and other powers, but you've really got to work in all of these things. When I first visited Roban as president of the National Native Title Tribunal, I can still remember in 1995, there were 38 different government programs projecting into Roban. And when you looked around Roban, it wasn't working. I think there's and I'm not sure to what extent that lack of coordination still exists. I think the Productivity Commission has had something to say about that recently. But it will critically, it will be dependent on how well the thing works.
Can I also just add to that? I want you to think about the legacy as well. The National Aboriginal Education Committee, of which Paul Hughes and Rex Scarlett here from WA were heavily involved with, negotiated with every Australian university for an Aboriginal centre in them and for Commonwealth to fund those. At the end of a 5-year period, every university in Australia had and has maintained Aboriginal centres of some description that have enabled students to have the support while they're at university. Now, that's a lasting legacy that will not go away. That's what we've got to look at for those committees that were abolished. What were their legacies that still prevail?
Okay, I think there were some more questions from this part of the... Yeah, the mic's coming down.
While we're waiting for that, there are 235 law graduates Indigenous law graduates from this university. Some people say any additional lawyer is too much, but...
Hi, my name's Francine Holder. I'm not a lawyer. I have a background in social work. I did a degree in anthropology with the Burnts, and I've also worked in prisons, in psychiatry and disability over my years of work. I'm retired. I've been concerned about the voice because I want yes to win, and I'm really worried about the way it's being presented to the Australian public. One of the things I learnt through my career was that you need to make the message simple so that everybody can understand it. And when I hear some of the information that people are speaking, people who have professional degrees always use jargon. They use big words that lots of people in the normal society don't understand, and the message gets lost. Now, they're all really great people. Ken Wyatt, you speak really well and simply, and I've been really frustrated about this. And so I wonder whether there's some way that what's being spoken by very learned people can be translated into language that everyone can understand. I mean, in disability, we learnt about simple language, and I understood that the law was changing from being very complex, particularly the written law, to being more simple. But giving a message is really important, and you see it very well in public health, which I have a master's in. And that is done by, I forget the doctor's name because I'm so anxious, but the ABC doctor who speaks so simply and knowledgeably, Norman Swan, yes. And that's the sort of language that we need to use to be able to get the general public understanding.
So we're approaching 8 o'clock.
Yes.
That's a good. So how are politicians and lawyers? How should we manage to talk more like Norman Swan? Was the question.
Well, he's had a long life of presenting medical.
So let's wrap up on that question. Actually, looking at the time, would anyone like to how do we... So I think the question is, how do we communicate? And in a sense, that's part of the rationale for this evening's panel. So I think it's a good question to end on. How do we communicate some of these complex questions about constitutional law, government, other legal issues in a way that is accessible and clear? And particularly, how do we do that in the run-up to a referendum that asks people to make quite a profound change to our founding document, the Constitution? Are there any concluding thoughts on that question?
Well, I agree with make it simple. I think the idea is a very simple one, and the establishment of an advisory body to advise the Parliament and the Executive about Aboriginal issues, matters relating to Aboriginal people. Now that can be stated simply, and in fact, I wrote a piece in, I think, The Australian, and many other people have also said, this is a really simple idea. Of course, that elicits the response, oh, you haven't given us the detail. You can't win. But I agree with you, there's a very important need for cut-through messages, and we should not underestimate the challenges that lack of civic education makes for us in this country. There are some people who still think The Voice is something to do with a musical competition. So I think you're absolutely right. I'm sure the government's well aware of that, and the proponents of the Yes campaign are well aware of it.
And I think actually going back to the Uluru statement, part of its power has to do with its simplicity and the language that's used and the way that it is heartfelt and avoids some of the legal technical jargon that can arise in these debates. So as I've said, it's 8 o'clock. I would like to mention that since we now have a date for the referendum, it is worth checking that you're enrolled, and if you're not enrolled, now's the time to do it, and it can be achieved simply by visiting the website of the Australian Electoral Commission. There are some forthcoming events of the Public Policy Institute that you may want to be aware of, and they're on the slide. But I'd like to thank everyone who's been involved in the organisation of this event this evening. I'd like to thank all of our panellists for generously giving their time to contribute this evening, and all of you for attending, and hopefully we will leave all of us as better informed voters than they were at the beginning of the evening.
Moderating in itself is a tough gig, and I think it's an even tougher gig with an issue like the voice, not the singing competition. So, although that would be a hard gig as well, I would imagine. So thank you very much, Murray. And also, thanks to the panel for their thoughts and insights and based on their experiences and their aspirations and so forth. And also thanks to Uncle Barry for his welcome to country as well. So thank you very much, everyone. We now do have a date for the referendum, and I would like to add that the PPI was at the Leadership Matters event yesterday with Anthony Albanese. So you can draw your own conclusions as to our impact on influencing policy by our presence at that event yesterday. I'm not saying anything, but we were there. And today we got a date. So coincidence? Possibly. Thanks to everybody for coming out tonight. Thanks to distinguished colleagues from UWA and from other universities and from the WA Parliament, and to all the ordinary members of the general public who came along tonight. I hope you are feeling more informed going forward and looking forward to the 14th of October, which will be a momentous and historic day in Australia's history. Okay, so thank you very much, everyone.